In this video, we will discuss about advisory jurisdiction of the Supreme Court. And this article 143 that says about the advisory jurisdiction of the Supreme Court. The Supreme Court of India has three kinds of jurisdiction. They are original jurisdiction, appellate jurisdiction, and advisory jurisdiction. And this advisory jurisdiction is says about this advisory jurisdiction article 43 is dealing with. And this advisory jurisdiction of the Supreme Court, we adopted this concept from Government of India Act 1935 and adopted to our constitution. So, what is advisory jurisdiction? It means when a particular question of law or fact has arisen, or there is a possibility that such a question of law can arise in future, and if this question is related with public interest, then the President can refer that question to the Supreme Court and obtain advice from this court. This is called advisory jurisdiction of the Supreme Court. And now such opinion of Supreme Court which they provide under the advisory jurisdiction, do it binding to all the courts of India? And different opinions were there. Like in the Kaveri Water Dispute Tribunal case, the common opinion was, yes, this advisory opinion has its own weightage and respect. So normally it is binding to all subordinate courts. That was the decision held in Kaveri Water Dispute Tribunal case. But in Ahmedabad, St. Xavier's College was the state of Gujarat. It was differently held. It held, no, it is not bounded to follow. Why? Because advice of Supreme Court given to the President is not a law declared by the Supreme Court. The advice given under under Article 143 of the Constitution is not at all a law. It is not a law declared by the Supreme Court. Hence, no subordinate courts are binding to it. Now, to know more about what is this reference means, let me explain some examples. First, we will look at how the reference made in Kaveri dispute. In this Kaveri dispute, there was a tribunal which was appointed by the central government, and the said tribunal directed Karnataka state to give a particular quantity of water to Tamil Nadu state. But what the Karnataka government did is they passed an ordinance in their state assembly not to obey this tribunal court's interim order. This matter later on referred as a question by the President to the Supreme Court, and the Supreme Court, after going through the merits of the case, decided or held that the ordinance passed by the Karnataka state legislature is absolutely an unconstitutional one. How? Because its main purpose is to nullify the order passed by the tribunal. What kind of tribunal? A tribunal which is constituted as per a central act. So which act is applied here? Here the tribunal has been constituted as per a central act, and the act is named as Interstate Water Dispute Act 1951. The Supreme Court again made a remark that here in this case the principle of rule of law also got violated. How? because the Supreme Court assumed that the state legislature themselves played the role of judge uh, in deciding this matter. So uh, the ordinance itself is unconstitutional, and at the same time, the um, ordinance is against the principle of rule of law. Now, the next case on which the reference was made is Ismail Faruqi versus Union of India. And in this case, the reference was something very sensitive. The reference matter was like whether a temple originated uh, or existed at the site, or where the Babri Masjid subsequently stood. Some sensitive, the question was something, or the matter was something sensitive. So the court politely declined in this reference to answer the reference, and because the stand Supreme Court had taken in this matter is like it's something related with the concept of secularism, so it would be unfair to make an advice on this. So it politely declined from giving advice on the reference. Then comes the Delhi law case, and in this case, the president's reference was related with the uh, an act, and how the delegated legislation would work on that act. And then comes the Barbari Union case, and in this case, the reference was how the territory of India could be transferred to Pakistan. Then in Sea Customs Act, the reference was related with the Sea Customs Bill, and Article 288 of the Constitution. Then there was Presidential Bill case, and here the reference were made related with the doubts in connection with the president's election. Now we will look into whether the Supreme Court is bound to answer the reference, or can it respectively decline to send a report to the president. That aspect we will discuss now. We can find it out with an example. That means in Kerala Education Bill, it was the duty of the Supreme Court to uh, entertain the reference made by the president and to give a advice on it. But in this case, in this Kerala Education Bill case, what the Supreme Court had did is like it had exercised its discretion, and it had a good reason that it politely declined from making an advice on the reference. Now the second point we are going to discuss is this: presidential is bound to is bound by the advice given by the Supreme Court. Means if any advice has been given by the Supreme Court, is presidential is really bound to obey that advice or have to work on it. Here the answer is the president is not bound to give effect to the opinion of the Supreme Court, which the Supreme Court had provided under Article 143. Because, but normally in cases, president would honor the and advice provided on reference, because the justification is the justification for the statement that the president is not bound to obey or not bound with the opinion of the Supreme Court is that it's just an opinion. It's neither a decree nor an order. So to be get enforced. So it is up to the discretion of the president that it can accept the advice given on reference or can reject it.